Hello everyone, welcome to Oliveboard. In this video we are going to discuss about the Indian Trust Act. So let's start the discussion. If we talk about the objective, we can see here that the act governs only the private trust and not the public trust. Okay, public trust are not governed by the Indian Trust Act 1882. So it governs only the private trust and the trustees only. Okay. The commencement date is 1st March 1882 and it's divided into 9 chapters, 96 sections and 1 schedule. You can see in the preamble as well, it is the law relating to the private trust and trustee, not the public trust. Okay. So this is an important point which you guys must be aware of. It states all the essentials of the trust and rules regarding the parties to the trust. The Act specifically states the creation of trust cannot be for an unlawful purpose. So there should be a lawful purpose. That's the first requirement. The applicability section is section 1. So section 1 is states that this act is particularly applicable to the whole of India and only to the private trust. Now this becomes quite important. You might be having a direct question in the examination regarding the applicability of this chapter, okay, of this act. So you should be aware of that it will only apply to private trust only. Public trusts are basically governed by the state specific act. There are so many states and each and every state will have its own specific law related to the public trust. So in case the state is not having any kind of separate act, then the state can refer definitely the Indian Trust Act 1882. Next, let's discuss about section 3. So basically section 3 states what trust is all about. Trust is an obligation annexed to the ownership of a property. So there is a property involved which creates an obligation for one party and arising out of confidence, right? So there is confidence involved in this, reposted in and accepted by the owner or declared or accepted by him for the benefit of another or another of another and the owner. So here there is a owner of this property, right? There is an owner of this property. He is handing over this property to a trustee. So that's create an obligation for the trustee. The trustee needs to take care of this property and definitely pass the benefit on to the beneficiaries, the real beneficiaries. So that's the definition. There are 3 features of trust. The obligation arises out of the ownership of the property, which becomes vested in a person called trustee. So let's suppose we are having a plot of land here. That's a property. Now here what the owner is doing, the owner is transferring a property to a trustee. Okay. So the obligation arises out of the ownership of the property which becomes vested in a person. So this property becomes vested in a person which is called as trustee, right? The obligation arises out of confidence reposted in and accepted by the owner. The third feature is the obligation is to use the property for the benefit of the beneficiaries. So now there are some beneficiaries as well. The trustee will be using this asset, will be keeping these assets for the benefit of beneficiary. That's the concept of trust. Okay. This concept is also called as ses qui trust. Okay. CES, ses qui trust. Hence the trustee and the trust property and the beneficiary are 3 essential that constitute the trust. Right? In order to constitute the trust, you must be having the trust property, beneficiary, right? And the trustee. Let's suppose, for example, A is the author of a trust. A transfers the property to T, which is trustee. So can I say that A is the owner of the property? A has transferred the property to the trustee, right? Now in trust to apply income or profit to provide medical facility to blind person what is the actual aim of A? Is to provide benefit to blind people. So he has handed over this property to Mr. T, who is a trustee, and now the trustee needs to be aware, is responsible for this particular facility. Okay. Now this is a valid trust. We are having a property. The owner has transferred the property to the trustee for the benefit of blind people. This is how the concept of trust works. Let's discuss about some of the terminologies. First terminology is the author of trust. So the person declaring the confidence, the person who hands over the property, that means the owner, is called the author of trust. Okay, the owner is called the author of trust here. Next is trustee. So the person accepting the confidence is nothing but trustee, right? To whom the owner is transferring the property is trustee. Next is beneficiary, the person whose benefit the trust is created. Now we have created the trust for the benefit of beneficiaries. Like in the earlier example, blind people were the beneficiaries. Next is trust property. So this is the subject matter of the trust. Let's suppose if I talk about land, building, then that's trust property. Beneficial interest, right of the beneficiary against the trustee. This is a right of the beneficiary against the trustee. That's beneficial interest. So beneficiaries are having beneficial interest in the property of trust. Okay. So we call it as tri-party agreement as well, because here we are having, in a trust deed, we are having author, trustee and beneficiary, three parties, right? So we call it as tri-party agreement as well. So the objective of the trust in general, so the main objective is that the trust should be created for lawful purpose, as we discussed. It cannot be an unlawful purpose. It must be a lawful purpose only. Okay. Let's say, for example, if Mr. X has stolen money from the bank and given it to Mr. Y with an intention of giving the money to poor children. So what Mr. X is doing here? He has stolen money, but the intention is good, helping poor children, right? In this case, the trust itself is a void, as the main purpose is unlawful, right? Intention kitna bhi acha ho, when the main purpose is unlawful, the trust will not be valid at all. Okay, it will be void. If the trust created for two purpose, let's suppose I have two purpose in mind. One is the legal one and the second one is the unlawful one, illegal one. In that case, if these purposes are not separable, then the whole trust will become void, because I cannot separate the legal thing with the illegal thing. So eventually this becomes a void trust, right? Because trust, in order to be a valid trust, you should be doing a lawful activity. That's the first key requirement, right? Now, as per section 4, all purposes are said to be lawful unless it is forbidden by law. Law ne hi mana kar rakha ho, defeats the provision of the law, it's creating a problem, it's defeating any purpose of law, right? Which has already been there. Fraudulent hai, fraud karne ke liye banaya gaya hai. Involves injury to another person and his property. So these kind of intentions won't be, tenable in the eyes of law. And immoral or against the public policy. The whole purpose is immoral, not moral, or it is against the public policy. In these cases, the trust won't be called as lawful. Okay, these are unlawful activity, and your trust will be definitely turned into void and not valid. Registration mandates for a private trust. Section 5 of the Act states that in case of immovable property, if immovable property is involved, then private trust must be created for a non just give me a second, guys. Yeah. So if the purpose, right, if the property which is being transferred is immovable property, right, so private trust must be created for a non-testamentary instrument, right? What is non-testamentary instrument? Basically, it's nothing but the trust deed only, right? So we have to execute everything on a piece of paper, which is called as trust deed, right? Further, if this instrument needs to be signed by the author of the trust or the trustee and has to be registered as well. So you need to get this instrument signed by the trustee, right? The author. However, if the non-testamentary instrument is created by a will, registration is not necessary. Now, what you guys need to remember is Section 5 states that in case of immovable property, right, you need to have an instrument in writing. Testamentary instrument you need to be having in writing, that too signed by the trustee and the author, right? However, if the non-testamentary instrument is created by a will, then registration won't be necessary. Okay. Movable property. A trust in relation to movable property can be declared in the case of immovable property or transferring the ownership of the property to the trustee. Hence, registration here is not mandatory. If we are talking about movable property, then registration is not mandatory here. Okay. Next, creation of trust, which is Section 6. So a trust is created when author expresses clear intention. Author needs to express a clear intention that what he wants to do, right? Purpose is very well defined. You need to define the purpose very well. Beneficiary is identified. All the beneficiaries are identified. ऐसा नहीं हो कि beneficiary के बारे में ही नहीं पता है. Trust property is specified unless the trust is declared by will or author of the trust himself to be trustee. Unless and until it is by will or the author of the trust is himself the trustee, sometimes the author in itself is trustee, right? In that case it is fine, but the trust property is specified, should be specified here. Okay, that's Section 6, creation of trust. Now you must be having a question like, who can create the trust? कौन बना सकता है आगे trust को? So trust may be created by every person who is competent to enter into contract. If you are legally eligible to enter into a contract, then you can create the trust, right? If a trust is to be created on behalf of a minor, if you want to create a trust on behalf of minor, now what is the problem? Minor cannot enter into contracts, right? A minor cannot enter into contracts. So if you still want to create a trust on behalf of minor, then the permission of a principal civil court of original jurisdiction is required. If you want to create a trust on behalf of minor, you need a permission of a principal civil court of original jurisdiction. यहाँ पे required रहेगी, right? So do remember this particular point. And it totally depends on the law as well, which is in force at the time of this particular scenario. Okay. Types of trust, as we all discussed. This act is applicable only to private trust and not to public trust, right? Now, what is private trust and what is public trust? You guys must be having a question in your mind, कि सर होता क्या है private trust, public trust? Private trust is of a closed group, right? It's a kind of closed group. In other words, the beneficiaries can be identified. Example, a trust created for relatives and friends of the author. Let's suppose I am the author. I have created a trust for the benefit of my relatives, for the benefit of my friends. That's a private trust. Okay. Public trusts are basically created for large groups. That is in public at large. Let's suppose we are operating a NGO, right? Non-profit NGO for charitable institution or for general public. Not to specific people, but to general public as a whole. Then in that case, it is treated as a public trust. Okay. Okay guys, let's continue. Section 8, subject of the trust. The subject matter of the trust must be property transferable to the beneficiary. What is the real purpose of creating trust? What we want to actually do? The owner of the property, the author of the property, wants to give the benefit of that property to a particular person, or I can say So group of bunch of particular category of people, that's the beneficiary, right? So the subject matter of the trust is property transferable to beneficiary. It must not be merely beneficial interest under the subsisting trust, but actually a property transferable to the beneficiary. Now an interest which is transferable cannot be a subject matter of the trust. We cannot have an interest which is transferable, we need to have a property. Okay. Section 9, who may be the beneficiary? Now every person capable of holding property may be a beneficiary. So there is no particular eligibility criteria for the beneficiary. If you can hold the property, then you are good to become the beneficiary. Okay. Disclaimer by beneficiary: a proposed beneficiary may renounce his interest under the trust by disclaimer addressed to the trustee or by setting up with a notice of trust a claim inconsistent therewith. So a proposed beneficiary may also renounce his interest, okay, may also transfer his interest. So here a particular proposed beneficiary can also transfer his interest under the trust, but he need to clearly give the disclaimer to the trustee for the same. A beneficiary may renounce his interest while he is proposed beneficiary by means of a disclaimer. So he needs to give a disclaimer to the trustee, right, for the same. But anyone can be a beneficiary. The only criteria is he or she should be capable enough to hold the property. That's it. So this act is quite straight, I will say. Okay, काफी simple act है. मेजर चीजें हैं, rights and duties हैं ट्रस्टी की, बेनिफिशियरी की, राइट, ओनर की, और बेसिक सी चीजें हैं, राइट. सो इस पे हम काफी सारे क्वेश्चन भी करने वाले हैं इन द एंड, सो दैट आपको यहाँ पे काफी चीजें क्लियर हो जाएगी. Section 10, who may be a trustee? Now who can become a trustee? So every person capable of holding property can be a trustee, but the trust involves exercise of discretion. He cannot execute it unless he is competent to contract, so he must be at least eligible for contract, right? No one is bound to accept a trust. Let's suppose nobody can forcefully make me a trustee, right? That's only as per my will only, right? That's obvious. Acceptance of the trust is accepted by any word or act of the trustee indicating with reasonable certainty, such as acceptance. Disclaimer of trust. Now instead of accepting a trust, the intended trustee may disclaim it also. Let's suppose I don't want to become a trustee, then I can disclaim it as well. That's also fine, right? Now such disclaimer shall prevent the trust property from vesting in him. I don't want to take care of that property, right? So I can disclaim it. I can disclaim it. That's also fine. Okay? That's also fine. Right? Now let's discuss about duties and liabilities of trustee. Okay, let's suppose I am a trustee of a property, then what will be my duties and liabilities? So this chapter prescribes duties and liability, which is the chapter 3 of the act, right? The success of trust entirely depends upon the act of the trustee. That's why we call it trustee. We have shown trust on him, right? And how he fulfills the obligation. So trustee is one of the most essential party in the trust act, right? Let's discuss about some of the duties of trustee. Just give me a second. Okay guys, trustee to execute the trust, the first duty is to execute the trust. That's the primary duty of the trustee, right? He's bound to fulfill the purpose of the trust. Whatever the purpose of the trust is, he is bound to walk on his talk, right? Must obey the directions of the trust. Whatever the directions are mentioned in the trust, he need to particularly fulfill those directions. Now there is an exception if modified by consent of all the competent beneficiaries. Sometimes, let's suppose we fixed a particular objective of a trust, right? Now all the beneficiaries have consented to modify the particular objective of the trust. Now that's also possible, right? Trustee is just the caretaker. He is not the owner of the asset. He is the caretaker. The real beneficiaries, we already know, are a bunch of particular group, right? Who can definitely divert the purpose. If beneficiaries is incompetent to contract, the principal civil court may provide consent. Let's suppose the beneficiary in this case is a minor. Now in that case, minor cannot give a consent, a legal consent. Then on behalf of the minor, principal civil court will be providing the consent, right? Because the agreements by minor are not at all valid, right? They are void from the very beginning. So a trustee is not required to follow the directions if it is impracticable. Let's suppose the directions are impracticable, then he is not under any obligation to follow them, or maybe illegal or injurious to beneficiaries. In that case, trustee will be good enough even if he don't comply with the directions which are harmful. So now let's suppose an example of a practical or illegal direction. Let's suppose a trustee is authorized to sell the land by a public auction. So I am a trustee of the property. I need to sell that land for the benefit of beneficiaries, that too in a public auction. Now I cannot sell it privately, right? I cannot sell it privately. That becomes illegal, right? That becomes injurious to beneficiaries. Why to do a private transaction when the trust deed says it all that I need to do a public auction? Okay. Trustee is to inform himself of state of property. So trustee must acquaint himself. He must be having a good understanding of the nature and circumstances of the trust property. At least he should be aware of like what thing he is considered as trustee for, right? प्रॉपर्टी का आइडिया तो होना चाहिए, किस चीज का ट्रस्टी बना हुआ है उतना तो पता होना चाहिए, राइट? द ट्रांसफर ऑफ प्रॉपर्टी, द ट्रस्ट प्रॉपर्टी टू हिमसेल्फ, रिकवर द मनी invested in hazardous security. So these are some of the duties of the trustee, I will say. Let's suppose if the trustee holds a debt on personal security and the instrument gives no discretionary power, the trustee may recover it immediately here. Okay, so these are some of the basic duties of the trustee. Trustee to protect title to trust property, so must defend the suit and take necessary steps to preserve the trust property and to protect its title. So preservation and protection of the title of that particular land or any other property, maybe it can be immovable, maybe it can be movable. Preservation and protection is the duty of trustee here, right? Trustee not to set up title adverse to beneficiaries. A trustee must not claim the title adverse to the trust, assist others in making any kind of adverse claim. He is the trustee, right? So his actions should not be like any kind of thing that is detrimental to the interest of beneficiaries, right? Care required from trustee. So trustee must manage the property as carefully as a prudent person, right? Prudent means intelligent backed by foresightedness. So a prudent person जैसा काम करता है वैसे ही a trustee need to carefully manage the property here. If handled carefully, the trustee is not liable for any losses due to destruction and deterioration. Let's suppose I am the trustee. I have done best what I can do to protect the property. Still there is a destruction, still there is a deterioration in the property. I cannot do anything because I have taken reasonable measures to protect it. I am a prudent person, right? I have taken the maximum possible things. Still there can be chances that something is destroyed, the property is destroyed, or there any kind of significant deterioration in it. Then I am not at all liable for it because I have performed my duty, right? I have performed my duty. Next is conversion of perishable property. Sometimes the property which is handed over to the trustee is perishable in nature. What do you mean by perishable? खराब हो जाती है, right? Deteriorate हो जाती है. If the trust is for multiple beneficiaries in succession and the property is perishable in nature, a future or revisionary interest is there, the trustee must convert it into a permanent income generating property. If the property is perishable in nature, then trustee can, kind of convert it into an income generating property, not to be not to keep it as perishable only, otherwise the property will be definitely deteriorated in the future. Trustee to be impartial if multiple beneficiaries exist, बहुत सारे beneficiaries हैं, then trustee must be impartial while performing his duties, right? There should not be a biasness. Court cannot interfere with the trustee's discretionary powers if exercised in good faith. If the trustee is exercising everything in good faith, then even the court cannot intervene in the process. Okay. Trustee to prevent waste. If one beneficiary in possession commits any kind of waste or damage, threatens to do so, then trustee must act to prevent it. If a particular beneficiary, right, commits any kind of waste or damage or threatens, even just threatens to do so, तो वहां पे ट्रस्टी को क्या करना पड़ेगा? He needs to protect the same. Accounts and information, trustee must maintain a clear and accurate accounts of related to the property. Provide beneficiaries full information on request. If any beneficiary want any accounts or any other thing, then trustee is liable to provide the same. Right? Now we have section 20, investment of trust money. If trust money cannot be used immediately, let's suppose we are having some money in trust, we can't use it immediately. The trustee must invest in the specified approved securities. It doesn't make any sense to keep the money as it is, right? It should generate a certain amount of return, certain amount of interest, right? And that's what section 20 tells us, that the trustee can invest the money but in specified securities only. So you should be aware of this list. You should be having a broad idea कि इसके अंदर क्या क्या securities आ रही है. सबसे पहले तो section 20 is very important, right? A trustee can invest the money in the approved securities. What are approved securities? It can be government securities like promissory notes, debentures, stocks of central government and and state government. Why? Because they are considered as secured. It's sovereign money, right? Government का money है, तो कोई टेंशन वाली बात नहीं है. Bonds and annuities secured by Parliament of India. Look at the level of security. They are highly rated bonds, right? They are having a good credit rating because they are backed by Government of India. Maybe it can be central, maybe it can be state government. Stocks, bonds or shares in railway or government guaranteed companies. You cannot invest the money of beneficiary in risky assets, right? That's why only government backed securities are there in the list. Municipal bonds, port trust securities or securities issued by the central or state act. So if any money is lying idle, then in that case the trustee can invest that money into approved security, and here is the list of those approved securities. Okay guys, first, mortgage on immovable property, other securities expressly authorized by the trust instrument. Let's suppose sometimes the trust instruments, right, the trust deed in itself specifies the securities in which you can invest your money, right? Invest the trust money, then that's fine. That's fine, because we are moving as per the trust deed only, right? The trustee is just complying whatever is stated in the trust deed, and that's completely fine. If an individual is entitled to receive trust income, investment in certain securities require their written consent. Okay, if the individual is entitled to receive the trust income, investment in certain securities will require a written consent in this case. Trustee have a discretion in investments, but they must follow the directions of the trust deed. Now this section definitely empowers a trustee to invest in approved securities, but this particular right, duty is not over and above the trust deed. Whatever is stated in the trust deed, the trustee needs to follow the directions. If a particular investment category is mentioned in the trust deed, then the trustee will definitely give priority to that. Okay. Section 20A, power to purchase redeemable stock at a premium. Trustee may invest in any securities mentioned in section 20. We saw whatever securities were mentioned in section 20, even if they are redeemable and exceed the redemption value. If I'm purchasing a thing, let's suppose at 102 rupee, and the redemption value means the amount which I'll be getting when the asset class matures, is just 100 rupee, still the trustee can do so. Now, will it make sense to purchase something at 102 and redeem it at 100 rupee? No, but the trustee can do so, right? He can buy things at a premium. However, there is a cap on it. There are some restrictions are there. A trustee cannot purchase any security if the security is redeemable within 15 years at par or at a fixed rate, and the price exceeds 15% above the par value. Let's suppose the par value is 100 rupee. Now, if the price is 120 rupee, then I cannot buy it. Why? Because it's violating my second condition. The price exceeds 15% of the par value. This is the par value. The price is exceeding 15%, right? That's an issue. There should be some amount of regulations, right? नहीं तो ट्रस्टी तो ऐसे तो बहुत महंगी चीजें खरीदने लग जाएगा. There can be manipulations in it, right? Now, a trustee may retain the redeemable stock, funds or securities until the redemption, provided the investment was made in accordance with this section here, right? So that's a easy section, I will say. Next is section 22. Sale by trustee directed to sell within specified time. What is the whole purpose of section 22? Let's discuss. If the trust deed instructs the trustee to sell a property, that too within a specified time. Let's suppose I am the trustee. I am bound by the thing that I need to sell a particular thing, that too within a specified time period, right? In that case, the trustee needs to follow those directions, obviously. If the trustee delays, let's suppose I delayed in that, right? I didn't sell that thing and I crossed the time limit. Then I need to prove that the delay did not harm the beneficiaries. मुझे prove करना पड़ेगा कि मेरी वजह से जो delay हुआ है, that's not harmful for the beneficiaries. If the trustee cannot prove this, then I am personally liable for any financial loss caused by the delay. अगर मैंने नहीं बेचा टाइम से, right? Let's suppose the property was worth 1,000 rupees. I didn't sell it timely, right? The property price went down to 950, let's suppose. Now this loss of 50 rupees is due to my personal negligence. I will be personally liable for this particular loss related to beneficiaries, right? Liability of breach of trust. If the trustee breaches the trust, he must compensate for the loss. That's obvious. If I have done any act which breaches the trust, I must compensate beneficiaries for the particular loss of that, right? Some exceptions are there. If the beneficiaries induce the breach through fraud, if competent beneficiaries consented to the breach. Let's suppose I breached. This is important. Let's suppose I did a breach and the beneficiaries consented to that breach कि हमको कोई दिक्कत नहीं है, we are fine with it. Then that's an exception. I won't be held personally liable for that, right? If the beneficiaries acted with full knowledge, right? So these are some of the exceptions. Liability for interest in breach cases. A trustee is not liable for interest payment unless they actually received the interest. There was unreasonable delay in the payment. They should have received interest, but they did not. In such cases, they must pay 6% simple interest per annum. Okay, so there is a liability for interest in breach cases as well. 6% simple interest per annum. No set off is allowed. A trustee cannot claim set off of losses from one breach against the gain of another. Let's suppose I am the trustee. I have made a breach of contract, right? And that resulted in 1 lakh rupee loss. But somewhere else I have earned 1 lakh rupees as well as gain. Now I cannot set off these losses. That अरे 1 लाख रुपए यहाँ पे कमाया तो था, so ये 1 लाख रुपए का यहाँ loss हो गया. No, you need to compensate the beneficiaries for the 1 lakh rupee loss that you made, right? because you didn't acted as per the trust deed. ऐसे set off possible नहीं है. Non-liability of predecessor's default. So trustee is not liable for default of the previous trustee. Let's suppose some other person was a trustee before me coming into picture. I am not liable for his or her defaults. Non-liability of co-trustees default. The trustee is not liable for the breach of another trustee. Let's suppose there are co-trustees. What do you mean by co-trustees? There are more than one trustee, I will say. Let's suppose there are two trustees. Now if number 2 trustee has done something, then number 1 trustee won't be liable for that, right? Okay. Unless and until, there are some exceptions as well, delivered the trust property without ensuring proper use. Now A must have fulfilled his or her obligations at least, right? Delivered the trust property without ensuring proper use. Person A, trustee 1, should at least ensure that whether trustee 2 is ensuring the property in use, whether the property is being used properly or not, as per the trust deed or not. Allowed a co-trustee to misuse the trust property. Let's suppose that trustee 2 is misusing the property. In that case also, trustee 1 should be aware of that thing, right? He should not have allowed such kind of things and failed to act despite knowing about the breach of trust. Okay, so these are some of the reasons here. Now the next section we are having here is several liability of co-trustee. If the co-trustee jointly breach the trust, each one of them will be fully liable, right? The co-trustee has done a joint breach. They have jointly breached some of the conditions that are there in the trust. Now they are severally liable, right? They are fully liable to the beneficiaries, but can demand contribution from the guiltier trustees as well. They can demand contribution from other trustees as well. Let's suppose we are having two trustees, 1 and 2. They both have done they both have kind of breached some of the conditions that are there in the trust. Now they are jointly liable for this breach. If we need to recover 1 lakh rupees, then they can contribute 50,000 because they are the trustees that have incurred this, that have resulted in the breach of this contract. So because of them there was a breach. Now they are liable for contributing, right? Non-liability of trustee without paying notice. If the trustee pays beneficiary without knowing about a legal transfer, they are not at all liable here. So small sections, but yeah, there are काफी सारे sections है इसमें, पर छोटे sections है, right? But most of them are self-explanatory. You just need to read it twice or thrice and you are good to go with this particular chapter. Okay, this particular act. ये Companies Act की तरह बहुत बड़ा act नहीं है, right? So there are small things, और last में हम questions भी करने वाले हैं that will definitely help. Those are some of the important examination questions only. Okay. Okay guys, liability of beneficiary's interest forfeited to the government. So beneficiary's interest is forfeited to the government if the trustee must follow the government direction here, right? Indemnity of the trustee not liable for losses beyond their control. I have done the maximum possible things that can be for the benefit of that particular property. Still there are losses, then not to worry, you guys are not liable in that case, right? As a trustee you are not liable for that. बैंकर का या ब्रोकर का मिसकंडक्ट हो गया, इन्वेस्टमेंट का फ्लक्चुएशन हो गया, यार इन्वेस्टमेंट का फ्लक्चुएशन हो गया तो इसमें ट्रस्टी क्या करेगा, राइट? They are only liable for the money actually received. Let's suppose there was an investment of 1 lakh rupee. The value came down to 90,000. Now the trustee is only responsible for the money actually received, right? Let's suppose I sold that investment for 90k. I received the money for 90k only, then in that case as trustee I am liable for that 90k only, not for that 1 lakh, because it was due to market correction, right? Not due to my misconduct. There are certain rights and powers of trustee as well, right? So in this chapter 4 we need to discuss about the rights and powers of trustee. So self-explanatory in nature most of the things, so we'll just quickly go through all the rights and all, right? Right to title deed. Trustee is entitled to possess the instrument of trust. So trustee should be having at least the instrument of trust. All the documents of title related to the trust should be solely be there with the trustee, right? So इंस्ट्रूमेंट ऑफ ट्रस्ट हो गया, डॉक्यूमेंट के टाइटल हो गए, अब टाइटल ही ट्रांसफर हो गया ट्रस्टी को, तो ऑब्वियसली ही मस्ट बी हैविंग द पोजेशन ऑफ इट, राइट? ही मस्ट बी हैविंग द पोजेशन ऑफ इट. Right to reimbursement of expenses. Trustee can reimburse himself or recover expenses from trust property for executing of trust or executing the trust preservation or protecting the beneficiaries and all. So he has the right to reimbursement of the expenses. Let's suppose as a trustee I have personally incurred 10,000 rupees for the benefit of that trust. Now I am eligible for the reimbursement of that expenses, right? Next is right to be repaid for overpayment. Let's suppose I have mistakenly overpaid beneficiaries. I was liable for paying 1 lakh rupees only, but I paid 1,05,000. So that's my right that I should be getting the refund of that overpayment. Okay. Right to indemnify from a gainer by breach of trust. If a third person other than the trustee gains from the breach of trust, they must indemnify the trustee, right? Let's suppose a third person have breached the contract. Now he needs to indemnify me. That's my right. That's my right. Okay. Right to apply to court for opinion on trust management. So we'll be briefly discussing these rights and all, because most of them are self-explanatory only. I won't be taking much of your time in these rights and all. You can just have a reading. That's again fine, right? Not to go into too much details of these rights and all, because the starting part was quite important, right? Iska, and the questions that we'll be doing will be quite important for your examination purpose. Rest, अगर आपको एक broad understanding भी है, bird eye view भी है, तो भी that will be also fine, right? Right to apply to court for opinion on trust management. Now trustee can apply to the principal civil court for advice or direction, right? For clarification on any legal matter. Now that's my right to approach principal civil court and get some guidance, get some advice, get some clarification if there is any kind of confusion in the trust deed or the intent of beneficiaries, right? I can always reach out to principal civil court for clarification purpose, right? Right to settlement of accounts. Now trustee completes their duty. When a trustee completes their duty, he has the right to get their accounts examined and settled, receive a written acknowledgement that no money is due to the beneficiaries. Now as a trustee, I have a right that I should be receiving a written acknowledgement कि मैंने सारा पैसा disburse कर दिया है beneficiaries को. Now nothing is pending at my end, right? That's my right. Power of trustee. Now he is having a general authority. Trustee has the power to protect the trust property, benefiting from the trust, supporting the beneficiary who cannot contract, right? Let's suppose there is a minor also as a beneficiary. So trustee here has the power to support that beneficiary who cannot legally enforce his right as of now, right? Trustee cannot lease the trust property for more than 21 years without court approval. Now that is important. You must be aware of that thing. जहाँ पे भी limits आ जाती है, right? Applicability, limits, ये सारी चीजें important हो जाती है. So as a trustee, I cannot lease that trust property for more than 21 years without court approval. उसके लिए मुझे court approval लगेगा. Okay? The trustee must fetch the best reasonable rent for it. अगर मैं कुछ rent पे दे भी रहा हूँ तो वहाँ पे मुझे सबसे best reasonable rent वहाँ पे fetch करने का देखना चाहिए. Power to sell in lots or by public and private sector, private sale. The trustee is authorized to sell the trust property, पूरी की पूरी, wholly या फिर in parts as well. He can sell it in public auction, in private contract as well, sell immediately or on different time period. ये पूरा का पूरा right उनके पास होता है, but it should be as per the trust deed की conditions. He need to follow the trust deed की condition. If there is any particular condition in the trust deed, तो उसको priority मिलेगी. नहीं है तो then trustee can definitely go ahead with his professional judgment. Okay, so these are some of the powers a trustee is having. Power to sell under special circumstances and power to buy in and resell. Now a trustee can insert conditions like sale agreement, proof of ownership. They can also buy back the trust property at an auction and resell it later. कहने का मतलब फुल राइट्स जो होते हैं उसको बाय कर लिया, वापस सेल कर दिया, वापस बाय कर लिया, ये सारी चीजें ट्रस्टी का राइट होती है, राइट पावर होती है उसकी. ओके, पावर टू कन्वे, ट्रांसफर ऑफ प्रॉपर्टी. द ट्रस्टी हैज पावर टू लीगली ट्रांसफर द प्रॉपर्टी फॉर आफ्टर द सेल. They can sign sale deeds. Now if I'm the trustee, then I do have exclusive authority to sell that property, right, for the benefit of beneficiaries. Obviously I can sign the sale deeds as well. Power to vary investments. Now trustees can switch trust investments but only within the approved category. So we have seen an approved category, right, section 20 वाली, उसमें हमने approved category देखी. Now the trustee can sell some assets. Let's suppose मुझे कोई state governments का कुछ bonds खरीद लिया. Let's suppose the trustee has bonds of state government. अभी समझ में नहीं आ रहा तो sell कर दिए. We can sell it. We can transfer it to some other asset class as well. But all these things should be happening in the approved securities. Only approved securities के बाहर you cannot go. Okay, right. Power to apply minors trust property for their maintenance. Now if the trust property belongs to the minor, then in that case trustee can use the income for maintenance, education and advancement of his life, right? Because the minor as of now is not capable enough, so the trustee can, as per his own judgment, can use the income which is being generated out of that asset for the maintenance, for the education, for betterment of his life, right? Religious ceremonies, marriage, funeral expenses and so on. If the minor's income is insufficient, then the trustee can apply the principal amount but only with the court approval. Let's suppose the trustee is having 50 lakh rupees property as property. Now the trustee is using only the interest which is being generated on this 50 lakh. Let's suppose is 50 lakh rupees पे 2 lakh rupee का interest generate होता है. 2 lakh rupee interest is being generated from this 50 lakh rupee. Now the trustee can use this 2 lakh for the benefit of minor, for the maintenance, for his education, for advancement of his life, right? Like that. He can also use this principal amount of 50 lakh rupee for the benefit of the minor, but only with the court approval. यार principal use कर लोगे तो फिर बचेगा ही क्या trust में, right? So that's why court का approval is must here. Trustee must still follow local laws governing the minor's property. He need to also follow the Trust Act तो follow करना ही है, trust deed के हिसाब से करना ही है, but also the local trust act governing the minor's property. Okay. Power to give receipts. The trustee can issue a written receipt for money received or securities and property transferred. Right? तो receipt दे सकता है, बहुत ही common power है यहाँ पे. Power to compound and settle the claim. 2 or more trustees can together accept a settlement instead of a full payment. Extend the time for the debt repayment. कोई डेट दिया हुआ है, लिया हुआ है तो उसका टाइम एक्सटेंड कर सकते हैं, कॉम्प्रोमाइज कर सकते हैं, सबमिट कर सकते हैं क्लेम टू आर्बिट्रेशन, राइट, और रिलेटेड काफी सारी यहाँ पे पावर्स गिवन है. बेसिकली दे हैव एक्सक्लूसिव राइट्स टू कंपाउंड एंड सेटल एनी काइंड ऑफ क्लेम. पावर ऑफ रिमेनिंग ट्रस्टी व्हेन वन ट्रस्टी disclaims or dies. Now there are several trustees here, right? They have the power over the trust property and one resigns or one dies. Let's suppose there are 2 trustees and Mr. B resigns or dies. The remaining trustee can still act unless the trust deed requires more trustee. If the trust deed is silent, then Mr. A is good to go ahead and take it forward. But if the trust deed explicitly states that you need to appoint more trustee, we need to have at least 2 trustees, then in that case Mr. A need to appoint another trustee. The beneficiaries need to appoint another trustee for that. Okay. Suspension of trustees power by court degree. A court can issue the degree on the execution of the trust, right? Cannot act independently or more. मतलब कोर्ट बेसिकली क्या कर सकता है, रेस्ट्रिक्ट कर सकता है पावर्स को ट्रस्टी की, राइट? मस्ट फॉलो द कोर्ट्स ऑर्डर, कोर्ट का ऑर्डर फॉलो करो, या फिर आप इंडिपेंडेंटली एक्ट नहीं कर सकते, यू कैन नॉट एक्ट इंडिपेंडेंटली इफ द कोर्ट डिग्री इज देयर, राइट? कोई अपील पेंडिंग है तो फिर अप्रूवल आने दो अपीलेट कोर्ट का. इस तरह से कोर्ट कैन डेफिनेटली restrict, I will say, the powers of trustee here. Okay. Next, disabilities of the trustee. So this chapter basically discuss that what trustee cannot do. अभी तक हमने डिस्कस किया क्या क्या ड्यूटीज है ट्रस्टी की, what are the rights. In this particular chapter it states that कि ट्रस्टी क्या नहीं कर सकता है. No renunciation. Once the trustee accepts the trust, they cannot renounce it. एक बार आपने एक्सेप्ट कर लिया तो फिर उसको आप ट्रांसफर मत करो किसी और पे, रिनाउंस मत करो, राइट? बट द ट्रस्टी कैन रिनाउंस ओनली इफ द कोर्ट ग्रांट्स परमिशन. कोर्ट ने परमिशन दे दी रिनाउंस करने की, देन यू आर गुड टू रिनाउंस. बेनिफिशियरीज की कंसेंट मिल गई है, ऑल द बेनिफिशियरीज हैव कंसेंटेड दैट कि इट्स फाइन इफ द ट्रस्टी रिनाउंसेस, और इफ द ट्रस्ट डीड अलाउज द रिनाउंसिएशन, that too will be fine. Okay, if the trust deed announces, clearly states that कि renunciation possible है, renounce करना, तो फिर ठीक है. renounce करने का मतलब क्या होता है, ट्रांसफर करना. ट्रस्टी ए ट्रस्टी बी को ट्रांसफर कर सकता है, renounce बोलते हैं इसको, राइट? नो डेलीगेशन. ट्रस्टी डेलीगेट नहीं करेगा अपनी ड्यूटीज को या फिर किसी अपने भी पावर्स को किसी और पर्सन को. बट द ट्रस्टी मे डेलीगेट इफ द ट्रस्ट डीड परमिट. अरे ट्रस्ट डीड ही बोल रही है तो फिर क्या दिक्कत है, परमिट कर सकते हो, आप कर सकते हो डेलीगेट. डेलीगेशन बहुत जरूरी है, इस केस में आप कर सकते हो. बेनिफिशियरीज का कंसेंट मिल गया, ऑब्वियस सी बात है. इफ समथिंग इज रिटन इन द ट्रस्ट डीड दैट्स फाइन. इफ द बेनिफिशियरीज डोंट हैव एनी प्रॉब्लम अगेन दैट्स फाइन. और इफ द डेलीगेशन इज अ मस्ट, इट्स नेसेसिटी. Co-trustee, if there are 2 or more trustees, they must act together unless the trust deed states otherwise. So if there are more than 1 trustee, then they need to act together. दोनों का ओपिनियन सेम लेवल पे जाना चाहिए, कंसेंसस होना चाहिए, राइट? There should be consensus. Now trustee must act in good faith and exercise the reasonable discretion. Court can intervene definitely in the trust if the trustee is acting improperly. No remuneration. Trustees are not entitled to remuneration. If the trust deed is allowing it, then that's fine. If the beneficiaries are consenting it or the court grants it, then that's fine. Otherwise, trustees are not at all entitled to any kind of remuneration. Okay. Now this particular rule does not apply to official trustees. Let's suppose if the government has appointed any kind of administrator as a trustee, then he definitely will be receiving the remuneration, right? But in generally, trustees are not entitled to remunerations, right? No personal use. He cannot use the trust property for personal use. No purchase of trust property. He cannot buy the trust property or buy the interest of beneficiaries, right? Rights and liabilities of the beneficiaries. Now beneficiary is the person whose benefit the trust exists, right? Because of the beneficiaries only the trust is existing, right? That's the rule. So now beneficiary does not have an ownership over the trust property, but they have enforceable right. Beneficiaries are not the owner of the asset, right? As the name says it all, they are beneficiaries. उनको benefit होगा. They do have the enforceable right कि हमको benefit होना चाहिए इससे. But the real owner here is trustee, right? Books के अंदर, कागजों के अंदर trustee is the owner. Beneficiaries do have enforceable rights. They are the real parties to which the benefit must flow. So let's discuss about some of the राइट्स ऑफ द बेनिफिशरीज एज वेल, राइट टू रेंट एंड प्रॉफिट, तो जो भी रेंट आ रहा है, प्रॉफिट आ रहा है, वो बेनिफिशरीज को जाना चाहिए. राइट टू स्पेसिफिक एग्जीक्यूशन, इफ दे वांट द ट्रस्ट टू वर्क इन अ स्पेसिफिक मैनर then they can do so. Right to inspect documents, they can definitely inspect documents at any time, but they need to give a prior notice to the trustee. Right to transfer the beneficial interest, they can transfer their interest to somebody else, they can sell it, they can mortgage it, they can transfer it through will as well. Okay. Right to sue, if no trustee exists. If the right to sue means they can file a suit, right? If no trustees are appointed, then they can definitely, sue for that to appoint trustee. The beneficiaries can file a case and the court will execute the trust. Definitely the court will decide for the further course of action in that case. Right to have proper trustees. If they feel that their trustee is not proper, then that's their right, that they can demand proper trustees here. They can demand proper trustees here, right? Right to compel a trustee to act. They can force a trustee to act in a particular manner stated in the trust deed. Right to remedy against wrongful purchase if the trustee has illegally bought some property, right? Then they do have a right to act in against these kind of actions of the trustee. Doctrine of tracing. If the trust property is wrongfully transferred, if the trustee has wrongfully transferred it, the beneficiaries can follow the property to the third party, sue for a declaration, recover the property or demand compensation, right? Let's suppose a trustee illegally invest 20,000 in a land. Then the beneficiary can claim the ownership of that particular land. That's the doctrine of tracing. They can trace it. Trustee ने 20,000 रुपए का अगर कहीं इन्वेस्टमेंट कर दिया लैंड में, तो दे ओन द लैंड नाउ. बेनिफिशियरीज डू हैव द क्लेम ओवर दैट लैंड ऑल्सो. Liabilities of the beneficiary. Definitely there are some of the liabilities as well for the beneficiary. They beneficiaries is liable if they join in breach of trust. They gain an unfair advantage from breach or any kind of breach they are making which is in violation with the trust deed as well. Right? Appointment and vacation of trustee. Now appointment of trustee. Trustee can be appointed by a person authorized by the trust deed. Whosoever is authorized by the trust deed can appoint the trustee. By the court if the original method fails. If nothing is there in the trust deed, then the court can also appoint trustees here. Okay. Next is vacation of office. If trustee vacates his office maybe by death or maybe by discharge, right? If by death, then the trust does not transfer unless the deed says it all. Discharge, if the trustee may resign if the trust is fulfilled. Trust का purpose ही खत्म हो गया है, fulfill हो चुका है, then that's fine. The trustee is discharged from the liability. A new trustee will be appointed. The court discharges them upon petition. So नया ट्रस्टी भी आ सकता है और कोर्ट भी उसको अपॉइंट कर सकता है. तो ये कुछ वेज हैं जिनकी वजह से वेकेशन हो सकता है ऑफिस का, खाली हो सकता है ऑफिस ट्रस्टी का. When does a trust end? ट्रस्ट खत्म कब होता है? जब उसका पर्पस अचीव हो चुका हो, राइट? पर्पस बिकम्स इलीगल. इवेंचुअली पहले लीगल था, इवेंचुअली इट बिकेम इलीगल. इन दैट केस ऑल्सो ट्रस्ट खत्म करना पड़ेगा. वी नीड टू एंड द ट्रस्ट. Fulfillment becomes impossible. Let's suppose the trust property ही destroy हो गई. Now we cannot fulfill the purpose of the trust. In that case also the trust is extinguished. The trust is revocable. The author revokes it. Let's suppose I was the author. I handed over the property to the trustee, but I made it clear in the trust deed that I can revoke it. I can take that property back anytime. In that case also the trust will be extinguished. Right? Revocation of trust. Now if there is any testamentary trust that is created by the will, there are two types of instruments, non-testamentary and testamentary. Testamentary trusts are basically created by the will. They can be revoked anytime, right? Will is just an intention. It can be revoked anytime. Other trust can be revoked if the beneficiaries consent to it. Trust deed allow करती है या फिर trust was oral with revocation clause. The trust created for debt repayment but the creditors were not notified. In these cases there can be revocation of trust. Okay, so this particular provision you need to remember कि अगर कोई ऐसा trust है that is created by will, then it can be revoked anytime. That's important. Okay, constructive trust. Now what are constructive trust? These are obligations similar to trust but they are not created by a trust deed. Okay, these are not created by trust deed. There are certain types of constructive trust. Resulting trust है, non-resulting trust है. Resulting trust means trust created when a legal owner did not intend full ownership. A legal owner उसको इंटेंड नहीं है कि उसको फुल ओनरशिप चाहिए, देन इन दैट केस रिजल्टिंग ट्रस्ट बनेगा. नॉन रिजल्टिंग ट्रस्ट, ट्रस्ट क्रिएटेड बाय लॉ इवन इफ देयर वाज नो प्रायर ट्रांसफर. ओके, सो नॉट सो इंपॉर्टेंट फॉर योर पर्टिकुलर एग्जामिनेशन पर्पस. देन वी आर हैविंग a particular doctrine here, right? Now this is used by charitable trust when the original purpose cannot be fulfilled. If you are not able to fulfill the original purpose, then you can use this Cyprus doctrine. Instead of letting the trust fail, the court modifies the trust objective. Let's suppose the original purpose is not at all possible. We are not able to deliver the original purpose. Now instead of letting the trust fail, the court modifies the trust objective to align it as closely as possible. Let's understand this thing with the help of an example. A scholarship fund. What was the original purpose of a scholarship fund? Somebody donated 50 lakh rupee to establish a scholarship for students studying nuclear physics. So particular person was generous enough to give a donation of 50 lakh rupees for students studying nuclear physics. Now after 20 years, no student has enrolled in nuclear physics. The sole purpose of the trust is defeated. We don't have any enrollment for nuclear physics. Now this makes it impossible to award scholarships, right? I cannot use that 50 lakh. अरे कोई होना भी तो चाहिए, किस पे यूज करो, right? So court decision क्या दे सकता है इस डॉक्ट्रिन के अंदर? The funds can be redirected to provide scholarship for students in related fields like physics and renewable energy. कोर्ट क्या कर सकता है? उस पर्टिकुलरली 50 लाख रुपीस को डाइवर्ट कर सकता है इनटू रिलेटेड फील्ड्स, कि फिजिक्स से रिलेटेड कुछ हो गया, रिन्यूएबल एनर्जी रिलेटेड कुछ हो गया. So now the original purpose तो cannot be fulfilled, but we can direct the trust activity to a better path. Right, that's the purpose of this particular doctrine. Beneficial interest, the beneficiary's right to trust benefit, it differs from legal ownership, right? Now beneficiaries do have beneficial interest, but they do not have ownership, right? They have beneficial interest, ownership lies with trustee. That's the sole purpose. Now let's try to do some of the MCQs around this particular topic, which can be very, very important for your examination as well. Okay, so we'll be doing multiple MCQs on the Indian Trust Act that can be important for your examination. The first is the Indian Trust Act 1882 is applicable to which of the following entity? Is it all kind of trust, या फिर सिर्फ public trust, public charitable trust, private charitable trust, or only private trust? So what's your take on this, guys? What should be the correct answer here as per your opinion? Let me know in the comment section. What should be the correct answer here? What should be the correct answer here? That's quite easy. That's the first thing that we studied in today's class, right? Correct answer here is private trust. Okay, as we know that the Indian Trust Act governs only the private trust. All the public trusts are governed by the respective state acts. However, if the respective state act is silent on a particular thing, then you can reference the Indian Trust Act. You can take reference from the Indian Trust Act. Now, a trust is defined in which section? Is it defined in section 4, section 3, or has no certain definition at all? Or is a part of uncodified law, or none of them? What's your opinion on this particular question? It is defined under section 3 of the act, right? It is defined in the section 3 of the act. It outlines that the essential element of the trust, including the roles of the author of the trust, the trustee, and the beneficiary as well, right? So we have discussed about this as well. The correct answer is option B. Which of the following is not true about a trust? क्या ट्रस्ट के बारे में इनमें से सही नहीं है? Okay. An obligation annexed to ownership of the property. Trust property must be transferable. Trustee can be a minor. Trust of immovable property is not valid without instrument in writing given effect to creation of it. Both C and D. The correct answer here is C. Trustee can be a minor. This is not true. Only that person can become a trustee who is eligible to enter into contracts, and minor is not at all eligible to enter into any contract legally, right? बाकी सारे points यहाँ पे सही है, ये particular है जो सही नहीं है. Next is, which of the following duties of a trustee? Which of the following are duties of the trustee? To prevent waste, conversion, to settle accounts, A and B, या फिर A, B and C. Correct answer here is A and B. Prevent waste and conversion, right? That's the correct answer. Now, what is this particular trust doctrine is all about? This word we have seen, sesqui. We have seen it. Is it related to beneficial interest of the beneficiary, trustee, author of the trust, trust property? The correct answer is beneficiary. The term is a historical legal term used to refer to the beneficiaries. So this is nothing but the synonym of beneficiaries only. You must be aware of this particular term. It can come directly in the examination as it is. Okay. Who can disclaim a trust? Trustee, beneficiary, author, or trustee or beneficiary, or all of them? The correct answer here is A and B, trustee and the beneficiary only. They can disclaim the trust, as we saw it in the provision as well. The essentials for creation of trust are specified in which section? Section 6, 5, 3, 4, 2. Which section states the essentials for creation of the trust? Correct answer here is section 6, which gives the essentials of the trust, right? Now, who can create a trust? Any person competent to contract, a relative of the beneficiary only, or a minor, or A and C, or all of the above. The correct answer, this is quite simple. The correct answer is A and C here, right? Section 7, as per section 7, any person competent to contract can create trust, right? Now, some of you guys might be having a doubt कि सर minor कैसे बनाएगा, क्योंकि वो तो competent ही नहीं है. देखो, the first person will be competent to contract, right? Second one can be a minor. It can also be a minor, but he can create trust through the guardian or legal representative only, right? That's the possibility. How can a trustee exercise acceptance of the trust? By words or by act with reasonable certainty? All of the above, none of the above. What should be the correct answer? Here the correct answer is all of the above, by words, by act, by reasonable certainty as well, right? You can exercise acceptance of a trust by any of the act here. Now, A and B are co-trustees of a trust. A dies immediately after making a breach of trust. Then who will be liable? Can I fix the liability of B in this case? The correct answer here is B and C. B is not liable for the breach of trust committed by A. B is liable if he conceals the breach of trust committed by A. Let's suppose B को पता था कि A ने कुछ problem किया है, right? B was aware of some facts, right? That A has done something wrong. A has committed a breach of trust. In that case, B will be liable. Otherwise, B will not be liable. Okay, otherwise B will not be liable. When co-trustee jointly commits a breach, then what will happen? Let me know in the comment section. When they jointly commit a breach, then what will happen? They are jointly liable or they are severally liable. Only one trustee is liable and collectively responsible for all. All are liable wholly, or A and B. The correct answer here is option D. All are liable wholly, right? Section 27 mein we have discussed about this particular question as well. Protection from liability of trustee is provided under which section? ट्रस्टी की लाइबिलिटी का प्रोटेक्शन कौन से सेक्शन में गिवन है? तो दैट इज गिवन अंडर सेक्शन 28 to 230, राइट? दैट प्रोवाइड्स प्रोटेक्शन टू ट्रस्टीज लाइबिलिटी फ्रॉम सर्टेन कंडीशंस. विच ऑफ द फॉलोइंग इज नॉट अ राइट ऑफ अ ट्रस्टी? कौन सा इनमें से ट्रस्टी का राइट नहीं है? राइट टू टाइटल डीड, राइट टू रीइंबर्समेंट ऑफ एक्सपेंसेस, राइट टू सेटल अकाउंट्स, right to transfer the beneficial interest, or none of the above. The correct answer here is right to transfer the beneficial interest. This is not at all the right. Otherwise बाकी के सारे right तो हमने पढ़े ही थे. A beneficiary has the right to follow the trust property which has gone to the third person against the intention of the trust. What do we call this principle? Now this is again important. The questions that I am discussing are very, very important, right? You can give a quick reading after watching this lecture. Give a quick reading to all the notes which are there in your course, and please focus on these questions. These are very, very important. The correct answer is option B, doctrine of tracing, right? A trust is extinguished when the purpose is completely fulfilled or its purpose becomes unlawful, when the fulfillment becomes impossible by destruction of the property, when the first being irrevocable is expressed revoked by the author. Obviously the answer is all of the above. We have seen everything in the provision, right? So guys, thank you so much for watching this video, right? So as I said, watch this lecture, revise everything by the notes. Just give a quick one or twice, read it twice at least, I will say, right? The notes, and just jump onto the questions. This is a very easy chapter, right? Most of the things are self-explanatory. You need to focus on sections, you need to focus on limits and some of the provisions that I have told you. Okay guys, thank you so much for watching this video.